Okay, so today we're going to look at the contribution of criminal pretrial procedures to effective access. So again, you need to know aspects of criminal pretrial procedures that help to achieve effective access. You also need to be able to discuss aspects that hinder effective access. Okay, so a typical exam question you might get is discuss the extent to which criminal pretrial procedures contribute to effective access. It could be worth up to 6 marks, and so for 6 marks you need to have 6 points. And so you need to have 6 things that either contribute to or hinder the achievement of effective access. Because it's a discuss question, you must have both sides. So you must have criminal pretrial procedures that help achieve effective access, and also some criminal pretrial procedures that hinder the achievement of effective access. So you must have both. It doesn't have to be an even split, doesn't have to be 3-3. You could have 4 things that contribute to and 2 that don't, or vice versa, or even 5 things that contribute and only 1 that hinders the achievement of effective access. But you just can't have only things that contribute to or only things that hinder the achievement of effective access. So firstly, some criminal pretrial procedures that help achieve effective access. Firstly, committal hearings. They ensure that cases with insufficient evidence do not go to trial. That reduces the costs involved in an unnecessary trial, and it also reduces the burden on the courts. It means that other cases are able to be heard effectively. Secondly, committal hearings actually allow the accused the opportunity to plead guilty. Again, that would avoid the cost of a trial, and it again reduces the burden on the courts and increases access for other cases. Some things that don't contribute to effective access or reduce the ability of the legal system to achieve effective access. Firstly, legal representation is needed for the pretrial procedures because of their complexity. That increases the cost involved. It reduces effective access for those with limited financial means. Committal hearings, because the majority of cases go straight through the committal hearing stage, they're not stopped there because of insufficient evidence. It would actually be faster and cheaper to go straight to trial. It's a waste of time really to have the committal hearing, some would argue, and would increase access if we just got rid of it. Finally, remand means that the accused is detained until trial if the court believes they're a danger to society or a flight risk. That means they may not have equal access to the courts as they're unable to meet effectively with their legal representation. They'd be unable to best prepare their case. So overall, we can say that despite some drawbacks, criminal pretrial procedures do contribute effectively to effective access to the legal system. And that's it.